unless we get a new bill assigned, we are not taking any bills by and having a special meeting for bills taken by. We'll do whatever we have to do if we get any new bills. But that's just a heads up. We have some folks who need to get back to some places, so we're going to hear Delegate O'Bannon right now, and then we'll hear Chairman Marshall's bill right after that. I think Delegate O'Bannon's bill is fairly straightforward, but come on up and
Thank you, Mr. Chairman. This is 1748, Health Law Section of the Bar Association. It clarifies who can work in the free clinic system. This is an indemnification, I think, which is...
I think it's an immunity provision.
It is an immunity thing, and Palmore here can speak to it, but it's those folks who work around that clinic setting. Jeff?
Thank you, Mr. Chairman, members of the subcommittee. Jeff Palmore with Reed Smith on behalf of the Virginia Bar Association. The code section that this is amending already provides liability protection for healthcare providers that are working at free health clinics around the Commonwealth. This would add to that those persons and individual and groups that organize, arrange, promote, or administer such services. That could be the church that hosts a free clinic in their fellowship hall, the Boy Scout troop that helps do publicity for one of these free clinics, and making sure that they have the same protections. If there is gross negligence or willful misconduct that takes place, they would still be liable for that.
So I think the charitable immunity doctrine would already cover those folks. The issue, as I read it, is that you have people who administer the service, administrative level folks, and other people who may be compensated for what they're doing. It's not charitable, but not a charitable role. This is picking those folks up and giving them the same protection the providers themselves have.
Like the administrator.
Yeah, you care? Okay. All right. Anybody here speak in favor of the bill?
We have a list of supporters: Medical Society, Nurses, Dental Association, Anesthesiologists, Health Wagon, and therapists.
Awesome. Anybody here speak in opposition to the bill? All right. Any questions for the patron or for the VBA? All right. We have a motion to report House Bill 1748. Moved and seconded. Any debate? Hearing none. All those in favor say aye. Aye. Those opposed? Thank you, sir. All right, Chairman Marshall. This is your Dan bill, filing bill.
Yes, sir, and I'd like to make an amendment, if I may.
All right, let's pull this up. House Bill 1699. I think your Housing Commission's taking a look at it too.
Yeah, all last year. And so what I'd like to add at the end of line 13, it says ordinance adopted by the City Council. I'd like to add after a public hearing.
All right, so if you have the bill in front of you, that says such pilot project may only be established by ordinance adopted by the City Council. Insert after public hearing.
Yes, sir. If that's a correct place to put it.
Got that, Fred? So I'm not on cities, counties, and towns. I don't know what all the rules are for public hearings and everything. Does anybody who say you local government any problem with sticking that in there? All right, would you like to make that motion as an amendment, Scott? All right, move to second that we amend the bill to add that clause at the end of line 13. Any debate here? None. All those in favor say aye. Those opposed? All right, so the amended bill is now before us. Go ahead, sir.
So House Bill 1699 authorizes a pilot project with the City of Danville, supported by the Virginia Housing Commission. Virginia Housing Commission spent all last year looking at this idea. This is a very limited case. It provides the city an additional tool to collect delinquent taxes while at the same time not interfering with the overwhelming majority of deeds recordation. The bill will allow the Danville City Council by ordinance after public hearing to provide that no deed conveying a parcel of real estate that has an assessed value of $50,000 or less. This pilot program would not apply to certain other conveyances, instruments such as deeds of trust, deeds of easements, and deeds of conveyed property. The problem we have in the city of Danville, approximately 12% of the housing in Danville is vacant. And so these houses are being passed down, and we're getting so many, tax liens against these things that once they are sold, the tax is not getting paid for it. So what this will do is hopefully get some of the back taxes paid.
And the city director of finance in Danville, who's going to be having to do a bunch more work, they're all good with this, right?
Yes, they were the one that actually brought the idea. This bill came from the city of Danville. I have some people here who'd like to speak.
Great, yeah.
If
If you're here to testify to the bill, come on up, introduce yourself, and offer your testimony. I thought you had Bullock coming up on your team.
Good afternoon. Elizabeth Rafferty with the Department of Housing and Community Development, and we support this bill as it will serve as a useful tool for the city to combat many of the pervasive issues of blight, vacancy, abandonment, and other issues resulting from absent, negligent, and tax delinquent property owners within the community.
Thank you.
Thanks on behalf of the Virginia State Realtors, and we worked on this legislation on version 7 or 8 or something with Delegate Marshall there on the Housing Commission, and we support the bill. And again, it's limited to a pilot project in the city of Danville for 3 years. We report back to the Housing Commission.
And now I'm not sure who's the right one to answer, because I read this, it carves out deeds of trust. So this would only be transfers of real estate by deed with no.
Mr. Chairman, I say that's correct.
All right.
The intent was to be able to capture, as described by the city officials, to capture the individuals who were trying to convey properties less than $50,000, and they knew that the taxes were owed, but they were trying to convey them through LLCs or whatever, and not pay the taxes. So this is a way to capture those. And again, by setting the threshold of $50,000 or less, it eliminates most normal transactions that would go through an attorney or through a title agency as a settlement agent.
And again, I'm not sure this view of the patrons of the bar, do tax liens attach to the property or the person who owes the money on the property?
Tax liens attached to the property.
Okay.
Jeff Palmer on behalf of the Virginia Bar Association. We are sensitive to the situation in Danville and appreciate what the patrons trying to do. I think we just want to, we have some concerns with the precedent that this sets about putting impediments on the transfer of property. If this were a statewide approach or didn't have thresholds in there, then we might object to it. But I think under those circumstances, we just want to raise the issue of the precedent that this sets that putting impediments on the transfer of property. Thank you.
Does the Housing Commission report to the General Assembly? It would be interesting for those of us who have this bill at this level to get to see the data that the Housing Commission gets, and I know you could help us with that.
Well, we can, if you want to add an amendment to include Greg B to this, we can do
We
that
may
also.
just make that standard on all legislation.
Okay.
Mr. Chairman?
Delegate Scott.
Thank you, Mr. Chairman. I'm just trying to figure out how this would actually work and what we're trying to get at. So I assume what I'm hearing is you got lots of property that's vacant and people die, they don't pay the taxes, and the city would have a lien against those properties. But what is this going to help with? The tax lien is still there.
I think what they're trying to get at is the guy who owes the taxes, so he gives the property to his brother or to somebody else, and that transfer. So yeah, the lien still attaches the property. That's why I asked that question earlier.
Well, that's still going to be a problem.
Mr. Chairman, I would say that, and let me put my clerk's hat on for a minute, the clerk in Danville has agreed to this as well. So what would happen is in the clerk's office, a deed that has consideration of less than $50,000, if it did not have the finance director's certificate on the top that the taxes are paid, then the clerk would send the deed back to the submitter and say, I cannot record this until such time as you get the certification at the top. So it's just the clerk checking for the certification for the finance director on any deed of transfer from one party to another less than $50,000. So that's the logistics that were discussed in the Housing Commission.
It's just so foreign to my experience that people who would buy property would not check out the title and therefore find a lien or not. That's what's boggling my mind.
So, Mr. Chairman, I would say that the experience and the testimony in the Housing Commission over a couple of different hearings about from the city of Danville was that the people know that their real estate tax is owing. They're not using a lawyer. They're not using a settlement agent. What they're doing is they're transferring property to avoid payment of taxes to another entity. And the expectation is that this will be a very minor portion of the transfers in the city of Danville. And again, we've accepted deeds of trust and all kinds of other transactions, just trying to get at that narrow focus
So let's say somebody does this deed, consideration is $40,000, they show up in the clerk's office, and it doesn't have the seal from the finance person.
Correct.
It doesn't, you can't record it, even if there are no taxes due?
Mr. Chairman, I'd say that Village of Toscano, that the purpose of the bill would be to require the certificate from the Director of Finance, and if it's not on top of the deed and the $40,000 deed that you described, then the deed would be returned to the submitter. The submitter would then have to go to the Finance Department and say either the taxes have been paid or work out something with the Finance Director. This was modeled after legislation that was adopted in North Carolina on a local option basis. Delegate Marshall had this bill last year, a local option for all localities, and a lot of the stakeholders felt there might be some problems with that, but everybody was comfortable with giving it a try in the city of Danville on a limited basis for 3 years, and let's see how it works. So that's the basis of where we came from and how we got to where we are.
Mr. Chairman, this is a great bill for Danville and other places that might have blighted property, because we'll make sure that somehow those taxes get paid before any transfers occur.
So, Mr. Chairman, I'd say to Delegate Toscano, the concern that a number of stakeholders had was that if you start having the clerk reject a number of different deeds, that particularly with mortgages would be applicable to that property, then it could cause the loans to expire and create a whole host of other problems. So what we tried to do is narrow it to properties less than 50 grand and just in the city of Danville to see how it works, and then to look at the product, our experience, and then have further consideration of the House Commission.
I don't know if this question would be for Chip or for the bar or for anybody up here who does real estate law, but I think you normally go to closing, money is handed over probably before the deed is recorded, isn't it? But it's held in the attorney's trust account, and so you would essentially unwind the transfer. The deal wouldn't close because you couldn't disperse the money because you couldn't record the deed.
Mr. Chairman, I would say that what would happen is in a transaction where there's a settlement agent and the buyer who's buying the property doesn't want to buy the property subject to the real estate lien. So what would happen is the settlement agent would collect the money, pay the real estate lien as part of the settlement on the property. So that's the way it would work in the vast majority of transactions. And again, this bill doesn't change that. It just changes the situation of what the city can do and what the clerk should do in a circumstance where there's distressed property, if you will, and somebody's trying to avoid paying their real estate taxes and not using the settlement agent. Because anytime you use the settlement agent, the taxes would be collected and paid.
Come on up, sir. How are you? It's good to see you.
Maybe a quick comment. I appreciate the fine job that Delegate Marshall and Chip Dix have done. Let me just add a couple of things on behalf of the city of Danville. Last year, Delegate Marshall's bill was local option statewide. Did not matter about the amount of money involved in the transaction. So this is really, really narrowed down. Having been a former practitioner in Danville, it's been my experience, and typically for these kind of transactions, you don't have a lawyer involved in the closing. You wish you did. You get the taxes paid then, because the seller doesn't want to take property with a lien on it. But typically it's when a person comes into the law office and here's my daddy's deed. Will you draw it up and put it in my name? That's all the lawyer does. Lawyer charges him for the deed, and then the client signs it, or gets it notarized in the law office, takes it to the clerk's office. That's all this is designed to do, is to help catch those people. Doug Kilgore had a boyhood friend who was my law partner, who was head of our real estate section, and these deeds just drove him crazy. We didn't even want to see them. But that's what it's designed to get at. And to the Virginia Bar's point, it's just a pilot project. If it's cumbersome, it won't be statewide. If it doesn't work in Danville, I wouldn't work in Charlottesville. In Danville, the Director of Finance office happens to be right down the hall from the park, which made it very convenient. I didn't have to go to another building to the third floor, fourth door on the left. So we think it's a very modest effort to see if that city, with all of its
switch to get the report to courts, or you just want
Are
us to?
you still gonna be chairing Housing Commission?
Uh,
I'll call you.
yes, they hadn't done a coup yet, so.
Right. Nobody else wants it. It's like Code Commission. We let John Edwards be in charge. Is this just, I think we may have to have an 80% threshold with the special legislation question. So, I don't know pilot programs if that applies. Let's assume it does for the moment. Yeah, I think it's, okay.
Very special.
I actually hated this bill a couple years ago, and I think actually this is the right way to do it. Make it damn well stupid on a pilot basis and see if it works or not. So I think it's probably been worked out pretty well. Anybody here speak in opposition to the bill? Anybody else in the audience here speak? Yeah. Any scofflaws in Danville here to testify? All right, we have a motion and a second to recommend reporting the bill as amended. Any discussion? All right, hearing none, all those in favor say aye. Aye. Those opposed? All right, thank you, sir.
Thank you for your time.
For the patrons sitting out here, we're probably gonna be a while. So if you got other places to go, just come and go and check in, and I've got a list here, we'll call people in this order. If you're not here, we'll just get to you when we get back in the room. So like Simon, gonna be a while. Lindsay's gonna be a while. I'm just everybody's is till we get a hold of it. And then it's not. All right, Delegate Yost, is he in here? Nope. Delegate Will. Come on up.
Yes, my apologies, Mr. Chairman, for looking if Yost was in the room. Mr. Chairman, thank you, committee members. This is what I believe to be an efficiency measure, House Bill 2276.
And there's a substitute to this that's in your packet in front of you. 2276. All right, go ahead.
Thank you, Mr. Chairman. And what it deals with the issue of incorrect information given on that's submitted for death certificates, and then the process in correcting that information. Traditionally, it has to go before a judge and have a hearing. What this legislation does would allow the judge to still look at it, sign off on it, and if he or she so desires, still call a hearing. But if not, they can sign off on it, it comes back through the clerks, and the changes are made. That's.
All right, has subcommittee had a chance to look at the substitute? All right, everybody's good? All right, we have a motion on substitute? Can you, all right, real briefly, so we have a motion to adopt substitute, moved and seconded. Before we vote on that, we have Doug Steiner would like just a brief explanation about the changes the substitute made from the introduced bill. Do we have any for the folks? Come on.
Chairman Chip Dix to the clerks, and the changes from the original bill basically are more stylistic and clarify the relationship between the various different parties here. So the original bill requested that the clerk be able to, without going to a judge, make certain decisions and changes in the death certificate. The clerks were concerned about that because we felt like that the clerks didn't have that statutory authority. So we worked with the funeral directors and Office of the Executive Secretary and all the other stakeholders and came up with a solution to streamline the process, including the Department of Vital Records. And so the idea is that between the original bill, which had the clerks making this decision instead of going to the judges, what we've done is we've said these are the bucket of things that the state registrar can do, and then when the state registrar can't do something, OES has created a form petition, which can be submitted, and then the clerk would receive that information. It spells out in detail that there would be an affidavit, which of course we all know as lawyers is sworn to under oath, and therefore can be admitted into evidence and submitted to the judge with a suggestion that under that circumstance, if it's something that the judge feels comfortable doing without a hearing, the judge can go ahead and do that, and then the process establishes clearly the service of process. It sort of creates
seen these bills, what you see in here, which is a reference not just to the county or the city in which the person resided, but also the circuit court of the city of Richmond. Why is that there? There's got to be some history behind why that's written that way.
So, Mr. Chairman, I'd say to Toscano, my understanding of the reason that the city of Richmond is mentioned is because the state registrar is based in the city of Richmond, a state agency. And so therefore, it would be appropriate if there was some dispute or something that needed to go to court, it would go to the city of Richmond Circuit Court as opposed to a local circuit court in a jurisdiction where the party became deceased.
Okay. All right, let's vote on the substitute, and then I know I've got a bunch of questions that we talked about earlier today, and go from there. So, all right, we have a motion and a second to adopt substitute. All those in favor say aye. Aye. Those opposed? All right, let's hear from folks in favor of the bill.
Mr. Chairman, my name is Larry Spiaggi, and I'm a funeral director here in Chesterfield County. I also represent the Virginia Funeral Directors Association. The purpose behind this is currently the process can take 8 months or longer to go through it. There was no real rhyme or reason of how it happened and all that. We just felt like this spelled it out. It did, as Chip said, it gives us a roadmap of what to follow, the forms that will be applied to it, and do that all along. I know there was some concerns and stuff, and we'll answer them if you have it. Okay?
Thank you, sir. All right, anybody else here speak in favor of the bill? I do think the substitute addressed some of the concerns. I've let Ms. Bisick know some other concerns I had. All right, anybody here speak in opposition to the bill? All right, let me enunciate my concerns, and then y'all can answer them. These are either concerns or issues for folks to be aware of. Issue number one, the where he resides is actually for the petitioner, not for the decedent. And so someone who is petitioning can file in any circuit court where they reside, as I read this, because any person may file a circuit court in which he resides. There's no limit on who could file, so in theory, someone totally unrelated to the decedent with no interest could go file in a remote jurisdiction. And the only service of process requirement is on the state registrar. It's not on interested parties, it's not on family members, it's not on next of kin, spouse, any of that kind of stuff. So those were the concerns I have with the bill as drafted. I do think taking the judicial decision away from the clerk and putting it in the court is the right way to do it, as long as the Supreme Court is comfortable that can be done by form, and I'm assuming they are because they didn't stand up. So, Mr. Dix et al., those are my concerns, who can file, where they can file, and who needs to get notice of it. And just want to make sure this doesn't set up a potential for abuse after the fact. I also think not allowing amendment of the cause of death this way actually takes away a lot of the other concerns too. So, all right, those are my concerns.
Mr. Chairman, I would say that I don't think from a clerk's perspective that we have any problem with editing the substitute to do that. I don't think the funeral directors do either. What happens, and I make the observation, we all know this as lawyers, what happens is when you start getting specific on certain concerns that get raised by individuals and departments and whatnot, you build that in, but you don't mention other things. So I think it was more of that we didn't cover the issues that you mentioned, but I don't think there's any policy concerns. I think the field directors would be happy to take an amendment to that effect.
Yeah, come on up.
Music, the MTA. Janet Rainey is Director of Vital Records, and she can explain how that works now and how this does not change any of that.
Hi, Janet Rainey, State Registrar of the Virginia Department of Health Division of Vital Records. A death record or any other vital record that's amended by my office is amended by a person with knowledge of the facts. So if it's an immediate family member that's petitioning the court for the amendment, be it spouse, parent, sibling, or the daughter child, or it could be the attorney that's representing the immediate family.
Okay. All right. Anybody else here to speak to the bill? Do you want to try to address my concerns, like before next Wednesday's meeting?
Mr. Chairman, we'd love to address your concerns before next Wednesday's meeting and be happy to work on language to address that. 2 days? This week. This week?
Yeah, this Wednesday. Anybody else on the subcommittee have any questions while they're here? I mean, the committee doesn't have to take the bill by Wednesday. You can vote it up or down now, or send it out of here. Those concerns would cause me to vote no for now, is all I'm trying to enunciate. So.
What is concern?
Yeah, so the concerns that I have, and it's not necessarily that they're bill killers, it's that we need to be aware of and think through. The first one is that there's no limitation on who can file this petition. So anybody, there's no need to have any kind of connection to the decedent. There is no limitation, the only limitation on where they file is that it's filed where the petitioner lives. I understand that for convenience purposes because the petitioner may be far away from where the person died. The problem with that is when you don't have a limit on who can file it, then a random person in Bristol can file a petition in Bristol for family and dead person in Fairfax. And then the third one is there's no notice or service on anybody other than the state registrar. Now, it might be that because there's nobody else listed in the death certificate, there's no way to give anybody else notice or identify who they should get notice of. I don't know what information the state registrar has. If they have a next of kin registry or something like that, I don't think they do. So it may be an unsolvable problem, but I could see a problem where some widow's husband's death certificate gets amended in a problematic way and they never even knew it happened. You know, the middle name gets changed or a maiden name gets changed or something like that.
Child from previous marriage or something, exactly.
Child from previous marriage wants to change the name on the record because that matters in some reason and nobody else knows it happened.
Mr. Chairman,
Doug Treason.
I have similar concerns, how that could impact also the insurance proceed. You know, how the insurance companies are not look for those kinds of differences. And if it has a name change or something like that, then the insurance beneficiaries may not be able to collect.
Well, and I think that's actually why you want the bill, because an error in the death certificate may prevent, and they need to come in and fix it. But the flip side is also the case that, you know, you could have two life insurance policies that because someone changed their name, the name on the life insurance policy looks different, and so you could end up with this becoming an issue.
Mr. Chairman, I think if you would be so kind as to go by for the day, we'll come back on Wednesday, and Delegate Wilt just mentioned to me that all of these things that the chairman's raised and delegates raised, these things that happen today. And so the problem with being specific and giving a roadmap is that you don't cover everything that is potentially an issue. And so we'll address these issues and we'll come back to you.
Right, and I apologize to Delegate Will. I talked to some of the folks today, but you and I hadn't gotten a chance to talk. We actually have another bill that has to go by for the day at the patron's request, which is Weber's, what's the number on Weber's bill? 1989. So let's have a motion on 1989 and 2276 to take them by for the day. All right, moved and seconded. All those in favor say aye. Those opposed, all right, we have adopted the substitute to Delegate Wilt's bill, so that's the bill that we'll be working from. Wednesday's our last meeting. It's going to be over at the Capitol on Wednesday.
Thank you, Mr. Chairman, committee members.
All right, Chairman Lingenfelter, you're up.
Afternoon, Mr. Chairman. Mr. Chairman, this is House Bill 1524. And let me just explain what this is about. When the bill was originally drawn, and I'll be offering an amendment to this, it basically said that it requires the mandatory liability insurance for special conservators of the peace, that's SCOPS, to be comprehensive general liability insurance. Now, we brought that bill, and if you look at the original language in the statute, is on.
Yeah, it's on line, it's section D on line 110.
Right. You will see that the original language said that an SCOP has to, an SCOP shall be covered by evidence of a policy of liability insurance. Didn't say anything about what kind of liability insurance. The DCJS has interpreted that in a way that they have created an insurance requirement that many SCOPs have a hard time getting. And so I spent some time this summer talking to the SCOP community about what they thought statute that would better define to DCJS what they should be requiring. And the language, Mr. Chairman, they recommended to me this summer was, in fact, comprehensive general liability insurance. Since then, Bob Bradshaw and some other insurance experts have come to me and said, no, that's probably not the best way to express it. I have put them together with the SCOPs, and now I have an amendment. I apologize for not submitting this earlier, but I have an amendment that can properly frame what kind of insurance we're talking about for SCOPs. So
Mr. Chairman, on line 111 on page 2 of the introduced bill, strike comprehensive general, insert personal injury. After the word liability, insert section 38.2-117 in parentheses. And
After the word liability, after personal injury? So between liability and insurance?
no, after yes.
Personal injury liability, and then that section, and then insurance?
Correct.
Okay.
And after insurance, insert to include professional liability insurance.
And what was the code section you cited?
38.2-117.
And what is that?
I think that's the appropriate site that should be there. I can leave that to council to say if that's redundant or unnecessary. But, Mr. Chairman, I guess what I'm trying to say to you is the insurance industry now has told, or at least the independent insurance agents, has said this is a language they feel best reflects what we're trying to do here. The SCOPs are fine with it. I have no idea what DCJS, what their opinion is, but I will tell you that what they've done in their regulations is created a situation, I don't know if I assume it was unintended, that has made it extremely difficult for SCOPs to get.
Is the board setting the amount of the insurance right now?
That's what they're doing.
And you know how much what they set it at?
I think they set it at 500,000. I think that's what they've done it at. I mean, in my view, it's whatever the traffic bears, whatever they think is appropriate to do. But it does seem to me we ought to be representing we ought to be requiring an insurance product that is reasonably available for an SCOP to secure. And they were having difficulty with the regulation that DCJS wrote. And so
Is
that's why-
DCGS here? Probably have some questions for you. So the question would be, what type of policy are y'all requiring under the statute as it exists now, and what limits are you requiring on that?
It is, as I said, it's law enforcement professional liability insurance is what's being required right now by regulation, and it's a limit of $500,000.
And SCOPs aren't qualifying for that special kind of insurance?
Very difficult.
That's what I hear is that it's difficult, but what I don't know whether it's difficult because they can't get it, or if it's an issue regarding price. I don't know one way or the other regarding that. I can say that since the regulations went into effect in September of 2016, 26 people have renewed and submitted their insurance.
Are SCOPs licensed through DCJS?
Registered, yes,
How
sir.
many registered SCOPs are there?
I don't know the exact amount. I believe it's in excess of 5,000.
5,000?
Yeah.
And 26 of them have given you their proof of policy?
Yes, but it depends on when it renews. It's a 2-year,
Okay.
and it could be new people, so it may not be a renewal. Every month we have a different group of people renewing.
See the insurance folks in the room? Yeah. I'm not even sure that you're gonna be able to get one of these policies that's gonna cover this kind of conduct anyways. You may run into the same problem where you were able to get this policy, but it doesn't actually protect them.
Right.
All right, so we kind of jumped out of order, so you hang on, don't go anywhere.
Okay.
Chairman Lingenfelter, I didn't mean to cut you off, but I was hoping they were here and could answer those.
No.
So do you have anybody here to testify to the bill or anything else you need to add?
I don't know if anybody.
Chairman Kilgore.
Doug, I'd say the best thing to do to make sure that you're covered is we can get Department of Criminal Justice, and I can maybe get some folks from Bureau of Insurance just to make sure that what you're wanting to do would actually cover them, because the chairman may be exactly right. We may be doing this and it not cover them at all because it would be excluded under a personal injury policy under that particular code. code section, so that'd probably be the best thing to do.
Here's the problem we have. This used to be a bond. And during our big study a couple of years ago on SCOPs, the idea was, well, why don't we replace bond with insurance? And so they did. And now it's very much complicated, the issue, because they're not like, the police department. They have policing powers. They may not have the ability to get the same policy as the Henrico Police Department does. And they're private business. I mean, they guard banks, they guard malls, they guard the airports. There are lots of things they do that's a public service. And essentially, by raising the bar and creating this very narrow insurance product available to them, you're going to drive some of them out of business because they're not going to be able to get the coverage. So what we're in search of, Mr. Chairman and Subcommittee, is an appropriate insurance posture for them so that they can continue to do their work. Now, if I may, and I don't want to complicate your day, but you'll recall today I asked the bill to go by on the floor. And I haven't completely vetted this with the patron yet, but it is similar in respect that it deals with security businesses and their insurance products, and I caught that today. And so this one came through general laws. I think, buddy, this was your bill. It came through general laws. My bill's coming through you. We need to get both of these bills in the same body and get them aligned properly, Mr. Chairman, which is why I have not spoken to Patron about this. We may want to re-refer that bill back to this subcommittee. I know, guys, I got it. I know, more work, I got it. But if we're going to fix this problem, we need to fix it one time.
What is it? What kind of insurance policy is his bill requiring?
His bill basically says liability insurance. That's all it says.
Delegate Chief.
Thank you, Mr. Chairman. Perhaps some of you guys who get insurance bills at Commerce Labor can answer this, but is the term comprehensive general, is that a defined term in the code, or is it one of these generic terms we don't really see it?
That's out in the substitute. He struck that comprehensive general.
We thought that was appropriate. But
they're striking that. The substitute we adopted, the amendment we adopted, struck that, put in personal injury liability, reference 38.2117.
Got it, okay.
38.2117 is the generic code section that just says a personal injury liability insurance policy is a insurance policy that insures you against personal injury, blah, blah, blah. And so then there'd be a bunch of, there are multiple types of policies that would be personal injury liability. This is a broad section. The issue is going to be, the same issue is, are they going to be able to obtain insurance that actually covers them for this type of behavior?
And, Mr. Chairman, the SCOPs I've spoken to tell me yes, that this would satisfy the language I've given you would work. Now, I know you want to vet it. I'm fine with that. We don't need to do it today. But we really got to get this right, because otherwise we're going to have the consequence of putting people out of business if we're not careful.
What we need to do is get the property casualty insurance folks, DCJS, and maybe someone from the Bureau of Insurance, to make sure that there are policies that apply. I'll give you an example. I had a brilliant idea a few years ago to require aviation insurance policies with a certain minimum for general aviation. Turns out nobody can actually buy it because it's too expensive. The market doesn't exist. So,
and that's what we're looking for, Mr. Chairman. We're looking for the sweet spot between what we ought to have, okay, and what is realistic to have. It's that intersection. And right now, I don't think we're there. Oddly enough, we were probably there with the bond, but we've done away with that. So now we're in the insurance area. So
yeah, I think that did screw it up. And there is a self-insurance provision in here.
that would be correct. And I would suggest the same language for Mr. Fowler's bill when it comes to a point where we can get them together.
Put the knife away, buddy. All right, Rick, we didn't adopt that amendment, I don't think. I think the right way to say it, the amendment that Chairman Lindenfelter is requesting is by evidence of a personal injury liability insurance policy as that term is defined in 38.2-117, or self-insurance. So I think that would be the proper amendment. Does that seem right, correct? All right, we have a motion on that amendment.
Second.
Moved and seconded. We amend the bill. All those in favor say aye. Aye. Those opposed? All right, I guess what my suggestion would be, if we're inclined to take this bill forward, to go ahead and do it with the understanding that DCJS, Bureau of Insurance, property casualty folks, are the property casualty folks not in the room?
Mr. Chairman, when is the committee gonna meet?
Only meets one more time, and it's Wednesday, and I would try not to get you jacked
Here's
up
what I
on
would
that.
do. I will get DCJS and the Bureau in my office,
Okay.
and I would do that tomorrow, and I would try to see if we can't get some kumbaya.
So you want us to take a buy and then here, finally on
No,
Wednesday?
if you're fine with taking it to the full, we can show up with the full and then dispense with it by saying either we have agreement or we don't have agreement, and then the full committee can vote as they will.
Everybody good with that? I'd suggest you try to find Legault or one of the other property casualty guys.
I'll get it.
Get them in the room. All right, amended bills for the committee. Any questions for the patron? Anybody else here to speak in opposition to the bill? Are you ambivalent? You don't care, right?
The administration does not have a position.
You're fine. I think Chairman Lingenfeld would like us to advance his bill to full with the understanding that he may have some additional testimony at full. If that's what we do, Andy, we'll put it on the contested docket just so doesn't get moving too fast. All right, bills for the committee. All right, motion to report, House Bill 1524 as amended, moved and seconded, any debate? Hearing none, those in favor say aye. Aye. Those opposed? All right, we'll keep it on the regular.
Mr. Chairman, just as a footnote, I'm gonna talk to Buddy, and it is possible that we may be putting a U-turn on that to get it straight, or continue to take it by until we can drop a floor amendment on it to make these consistent going forward.
Or you can do it on the Senate side.
Or we just kill it.
You ever seen anything like that before? Thank you, sir.
Thank you.
All right, Rush. Delegate Rush. So, yeah. Second.
Thank you, Mr. Chairman, members of the subcommittee. This deals with epinephrine for private and public higher institutions of higher learning. It's the same thing we did for our public and private K through 12 schools. It exempts from civil liability folks who have done the training and administer this drug in emergency situations.
And I think this is on line 119. This is this is a long immunity section, so this adds a 14 and is a public institution of higher education or private institution of higher education. It's supposed to mirror what we did before for K-12, right?
Yes, sir. Mr. Chairman, it mirrors section 13 of that. So it's the same language, it just adds institutions of higher learning for it.
Yeah, and I hate immunity bills, but I actually think this is sort of consistent with the policy that we've been enacting elsewhere. We certainly want to encourage folks to take these life-saving measures. So, yeah, right, you want to kill kids in college?
I don't.
All right, anybody here speak in favor of the bill? Anybody here speak in opposition to the bill?
Second.
Motion is second to recommend reporting. Any debate? All right, hearing none, all those in favor say aye. Aye. Those opposed? All right, thanks, sir.
Thank you.
Good job. All right, Delegate Yost.
Thank you, Mr. Chairman. This is House Bill 2324. And this bill was brought to me at the request of the Treasurers Association. A number of treasurers across the Commonwealth have sought to pay jurors by prepaid debit cards. And the recognition of the reality that substantial numbers of citizens do not maintain banking accounts. However, their local government attorneys and audit firms have called this question to practice since it's not explicitly laid out into the code. This bill just gives an explicit authorization
opposition to the bill? Or come on up.
Mr. Chairman, I'm Charlie Grossman. I represent the treasurers, and the delegate has explained it very well.
All right, fantastic. So the issues that have come up in the other bill are the question of consent and the question of notice of fees and stuff like that. And so there may be some people at some point, as that bill goes forward or dies, if they need to be aligned. Right now, you're picking up the right language that was existing about having one opportunity to withdraw with no fee. But there's not a requirement in here that they get notice of any fees that might happen after that first free withdrawal. And so that may be something that folks at some point want to consider adding to the bill goes forward. Now, let me mention.
Chairman, I think the Chairman is referring to a practice began, I think, in the administration, we did for income tax refunds, i.e. debit cards, and some people got them and they realized you get 100 cents on the dollar of your income tax refund debit card, you had to pay your bank a fee, and we went through a couple of years dealing with that, and finally I think the program was scratched. But I'm okay with the concept. What I don't want is some juror to get 99 cents on the dollar because there's a fee being taken out of the debit card. I'd rather than just get, legal tender if there's gonna be some kind of a transfer fee or convenience fee or whatever you call it for using the prepaid debit card as a part of your juror, just compensation.
So that is another analogous situation with the taxes. The bill that I'm talking about is a bill that Delegate Ward has that says, the current law says you have to pay your employees using cash, check, or electronic transfer. And she's adding in on these cards that you have to get consent from the employee and you have to provide them notice of any and all fees. I think she accidentally struck the one free withdrawal. So anyways, in theory, somebody could offer an amendment that said not only you had to have one free withdrawal, but that you had to provide notice of any fees that might go with the card. I don't think the patron's asking for that, and I think that's would only be necessary if that was the obstacle to the bill going forward. So,
Mr. Chairman,
Delegate
I don't know if I agree with the premise that every prepaid card has to have a fee. Is that correct?
No, doesn't have to.
The company that we over to the point that Randy raised is that was the company that we made the deal with to send out people's payments. But I don't know that necessarily means it has to have a fee attached. Unless I'm wrong. But
no, I mean, the law doesn't require to have a fee attached, but this just says if you do have a fee, you have to have at least one free withdrawal without any fees, and then they can start charging fees after the first time. And so one could, for example, say, hey, you ought to give them notice that after the first withdrawal, they have to start paying fees, so maybe they'll withdraw 100% the first time. Again, that notice of subsequent fees would be the only thing that someone else might care about, and I don't, because it's just. All right. I think I already asked. I know you spoke in favor. Anybody here in opposition to the bill? You care? You care? All right. All right, the bill is for the committee. Any questions for the patron? All right, we have a motion to recommend reporting House Bill 2324. We have a second? Moved, seconded. Any debate? All right, hearing none. All those in favor say aye. Aye. Those opposed? No. Okay, we have one no. So it's on the contested docket for full amendment. Yeah. All right, Delegate Bulova is up. Delegate Bulova has 2307.
Yes, sir.
Okay.
All right, Mr. Chairman and members of the subcommittee, House Bill 2307 deals with the cover sheet for land records. It's created by the Office of the Executive Secretary of the Supreme Court. I think you all know that HOA declarations under the Property Owners Associations Act represents a binding contract to future property owners, deals with everything from architectural review to parking to complaint resolution. Most of these declarations are very well crafted, but in fact, under the Property Owners Association Act, there isn't a list of standards or standard items that have to be in a declaration. So every once in a while, you do wind up with a
2015, the General Assembly passed legislation that had the Common Interest Community Board put together some best practices for declarations. They pulled together stakeholders and came up with what I think is a really good document that provides guidance on what should be in a declaration. So the next question is how do we make sure that that is used or at least reviewed and referenced? And so that's what this bill does. Last year I actually submitted a bill that went before counties and cities and towns looking at how to do that in one way. Frankly, the home builders didn't like that at all. But they also came back to me and said perhaps this is a better approach that they would be willing to support. And since all of these declarations have to be filed with the land records, the concept in here is just making sure that you have some simple acknowledgement that you've reviewed and considered the best practices that the Common Interest Community Board has put together before you actually file and make official the declarations that are going to be bound upon an HOA. So it provides continued flexibility, doesn't mandate everything, but just simply make sure that there is a marker out there so that these lawyers know that there's a resource available from the Common Interest Community Board.
Elegant Kilwood. What is that? What is that? There's a new term to me, the Common Interest Community Board. What is that?
Sure. Common Interest Community Board was a board put together, I want to say it was about 10 years ago, and